Do you think having a will avoids probate? That your spouse automatically inherits everything, or that you really don't need an estate plan unless you have a lot of money? If you believe any of these things, you may be making important decisions based on estate planning myths instead of New Jersey law. So, coming up in this video, you'll learn which common estate planning beliefs are actually wrong, what New Jersey law really says instead, and why believing one of these myths could create real problems for you or your family. By the end, you should have a much clearer idea of what to pay attention to when creating or reviewing your estate plan, so you're making decisions based on facts rather than assumptions. I once had a woman come in to see me after her husband died without a will. She believed that because she was his wife, she automatically inherited everything he owned. But that's not what happened. Because of their particular family situation, New Jersey law required that part of his estate go to his children. She came in believing one thing was going to happen and learned after her husband was already gone that the law said something very different. And that's the problem with estate planning myths. They can sound completely logical right up until the law produces a result you never expected. So let's look at 5 of the biggest ones I hear, starting with one that's closely related to what happened to that client. Myth number 1: if I die without a will, my spouse automatically gets everything. As the story I just told you shows, sometimes that's true, but not always. Under New Jersey's intestacy law, what a surviving spouse receives depends on the family situation. For example, the result can be different when the person who died had children from a previous relationship, when the surviving spouse has children from another relationship, or when a parent of the deceased is still living. You don't need to know who gets how much. The important point is this: if you don't make an estate plan, New Jersey law decides who receives your probate estate. And the answer may be very different from what you assumed. There's another myth tied to this one: that if you die without a will, the state of New Jersey takes everything. That's generally not what happens either. New Jersey law provides an order in which surviving relatives inherit property when there's no will, and it may not be what you want. Myth number 2: having a will means my estate won't go through probate. A will doesn't avoid probate because probate is the process through which your will is accepted and the person you've chosen is given authority to administer your estate. In New Jersey, county surrogates handle probate and estate matters. Now, having a properly prepared will can make your wishes clear and make part of administering your estate easier. But simply signing a will doesn't make probate disappear. And here's something that's especially important. You may hear a lot about how you need a living trust because probate has to be avoided at all costs. These trusts can make sense in some situations, but that doesn't mean everybody needs one simply to avoid probate. In an uncontested estate, our probate process can often be relatively straightforward. Myth number 3: my will takes care of everything. Your will is important, but it doesn't necessarily control everything you own. Some assets can pass outside your will and probate. Life insurance and retirement accounts may have beneficiary designations. Certain financial accounts may name beneficiaries. Jointly owned property by a married couple, like a home or a bank account, passes to the surviving spouse outside of probate, and assets held in a trust are governed by that trust. So you could have a perfectly valid will that says one thing, while a beneficiary designation on one of your accounts sends that particular asset somewhere else. That's why an estate plan is more than a will. All of the pieces have to work together, including a power of attorney, advanced medical directive, and living will. Myth number 4: estate planning is only for wealthy people. When people hear the word estate, they sometimes picture someone with millions of dollars, several houses, and a complicated financial portfolio. But estate planning isn't just about estate taxes or protecting a huge fortune. You may have a home, a checking account, a retirement account, a car, and personal belongings. You may also care very much about who receives those things and who handles everything when you're gone. Estate planning is really about control and decision making, not just how many dollars are in your estate. There's a related myth that says, I'm too young to need an estate plan. That's really the same mistaken assumption that estate planning is for someone else. Your family responsibilities, marriage, children, home ownership, or the possibility of incapacity can make planning important long before you consider yourself old or wealthy. And finally, myth number 5, if I become incapacitated, my family can automatically handle everything for me. This myth points to something people often overlook. As I said, estate planning isn't only about what happens after you die. It's also about what happens if you're alive but can't make decisions for yourself. That's where documents like a durable power of attorney and a healthcare advance directive become important. In New Jersey, for example, a proxy directive lets you appoint a healthcare representative to make healthcare decisions if you become able to make them yourself. Simply being someone's spouse or adult child doesn't necessarily give that person automatic legal authority to handle every financial or healthcare matter. Your will doesn't help you if you're alive, but unable to manage your own affairs. And once you realize there's more to an estate plan than just writing down who gets what, the next question is whether you can safely prepare a will yourself. There are several DIY will mistakes that can create expensive problems for you and your family. I cover the 5 biggest ones in the next video, top 5 DIY will mistakes that could cost you, so watch that one next. And if you live in Burlington, Camden, Gloucester, Salem, or Cumberland County, New Jersey, and have decided that you need an estate plan suited to your specific needs, then click on the link in the description to schedule an initial call with me. I can help.